Have you ever wondered what happens when a major protest meets the courtroom and the law flexes its muscle? Well, today we have exactly that, and it's unfolding live, right here in Nigeria. If you haven't already, make sure to like this video and subscribe so you stay updated with every twist and turn. Here's the gist. The Nigeria police force filed a legal suit against Omoyele Sowore and some others tied to a protest under the banner of Free Nnamdi Kanu now. The matter was before the Federal High Court, Abuja Division. The court has rescheduled the hearing of the suit to 5 November 2025. Let me walk you through it step by step, break it down so everyone gets it, and we'll also look at the wider implications together. So, what's exactly going on? Around 17 October 2025, the police moved an ex parte motion that means they asked the court to act without the other side being present, yet against Sowore, his media outfit, Sahara Reporters, Limited, and some groups tied to the protest. The motion asked for an order restraining them from protesting in certain sensitive areas in Abuja, such as near the Presidency, the National Assembly, the Force Headquarters, the Court of Appeal, Eagle Square, Shehu Shagari Way. The police argued that if the protesters were allowed to demonstrate in those areas, it would pose a threat to national security. The court granted the interim order, meaning the prohibition on certain protest locations was accepted for now. Originally, the judge, Justice Mohammed Umar, fixed 20 October for the respondents, that is, Sowore and the others, to show cause why the interim order should be vacated, that is to say, cancelled. But then things shifted. The matter was on the court's list for Wednesday, 29 October, but the hearing could not proceed because Justice Umar was absent. The court then fixed it for 5 November. Why should you care? Good question. Because this is more than just another court date. It sits at the crossroads of key issues. Right to protest versus public order. On one hand, you have citizens and activists exercising their constitutional rights, freedom of assembly, freedom of expression by organizing or supporting protests, in this case, the Free Nnamdi Kanu Now movement. On the other hand, the state, through the police, raises concerns about strategic locations and national security. How far this balance goes is often tested in court. Media and activism. Sowore isn't just any individual. He formally contested for president 2019 and 2023 under the African Action Congress, ACC. His media outlet, Sahara Reporters, is also caught up as a respondent. So, this case also highlights how activism, journalism, and politics intersect and how they can draw legal scrutiny. Sensitive locations and state spaces. The restriction on protest locations isn't trivial. Being barred from demonstrating near the presidency, the legislature, or other key institutional spaces means the state is trying to define the boundaries of public action. For citizens, this raises important questions. Where can we protest? Under what conditions? And when is the state's response too heavy? Timing and court process. It's notable that the judge was absent and hearing rescheduled. That delay itself creates space for public interest, discussion, and potential strategies from both sides. It also raises questions about pace of justice. Is justice delayed effectively justice denied? Let's look at some likely scenarios and what could happen next. The respondents, Sowore and his co-protesters, will have to contest the police's case, show cause why the interim order should be lifted. That means they will argue, we have rights, the order is too broad, the locations we protest in are legitimate, etc. The police will press that the interim order is justified, that the protest threatens public order or national security, and that the respondents cannot be allowed to demonstrate in those specified areas until the full hearing is done. On 5 November, when the hearing takes place, the court may either A. Set aside the interim order, B. Extend or affirm the interim order, or C. Modify the terms, for example, allow protest, but not in certain zones. The outcome will set precedents. how future protests of this nature will be managed, how state agencies will engage activists, media, how the courts will interpret national security in context of protest. What should you, as a citizen, watch out for? Keep an eye on the full court judgment. Interim orders are temporary. The substantive judgment will carry real weight. Monitor how protest organizers adjust. Will they change their plans? Will they comply with the interim order? Will they challenge it publicly? Follow how the media reports on it. Since a media house is involved, how journalists cover, interpret, and critique the process becomes part of the story. Pay attention to how national security is invoked. Sometimes it's legitimate. Other times it might be used to stifle dissent. Understanding this distinction is crucial. Check how the enforcement will work. Will the police enforce the order strictly? Will there be arrests? Will there be clashes? These on-the-ground dynamics often tell the fuller story. To wrap up this first part, here are 3 final thoughts for now. And remember, if you haven't yet, like this video and subscribe to the channel to stay tuned. While legal processes may seem slow, they are vital. What happens in court here influences citizen rights, activism, and the role of state power for years ahead. Behind the legal jargon and court motions, this is about power. Who gets to speak, who gets to protest, and how the state responds. For all of us, as observers or participants, it's more than just a headline. It's part of how Nigeria's democratic space evolves. Omoyele Sowore is not a stranger to controversy in Nigeria's political and civic space. He's a journalist, activist, and politician, founder of Sahara Reporters, a well-known online platform that exposes corruption and gives voice to social issues that many traditional outlets sometimes avoid. He first became a household name for his role in student activism back in the 90s during his university days at Unilag, when he fought against corruption and military rule. Later, he contested for Nigeria's presidency in both 2019 and 2023 under the African Action Congress, AAC. Now, to the present situation, this current case isn't happening in isolation. Sowore has a long history of being involved in street protests, civil rights advocacy, and campaigns against government excesses. For instance, you'll remember the RevolutionNow protest of 2019, which got him arrested and detained by the DSS. That incident led to major public debate about the fine line between protest and what authorities sometimes label as insurrection. Fast forward to now, the Free Nnamdi Kanu Now protest is another flashpoint. The protest is connected to the continued detention of Nnamdi Kanu, the leader of the indigenous people of Biafra, IPO. Kanu has been in detention for a long while, facing charges related to treasonable felony and other offenses. His supporters and human rights advocates have been demanding his unconditional release, arguing that his continuous detention violates human rights and court orders. Sowore, being a known human rights activist, aligned himself with that movement, not necessarily as a member of IPOB, but as someone advocating justice, rule of law, and free expression. That's what led to this whole police suit. The police claim that Sowore and others planned to protest in high-security zones, which they believe could destabilize peace and security in Abuja. Now, this brings us to an interesting question many Nigerians are asking. Is Nigeria becoming too sensitive to peaceful protests? Let's break it down simply. Under the 1999 Constitution, Nigerians have the right to peaceful assembly and freedom of expression. That means, legally, you can protest as long as you do it peacefully and don't incite violence. However, in practice, authorities often place restrictions citing security concerns, traffic management, or the need to prevent unrest. So it becomes a tug of war, protesters claiming their rights versus the government claiming its duty to maintain order. And here's what makes this case particularly interesting. It's not just about one protest. It's a symbol of how the Nigerian state handles dissent. When you watch this kind of situation closely, it shows how power interacts with freedom in our democracy. Now, here's something that most people might not have noticed. The court's decision to grant an interim order already gives the police a temporary win. That means, until the next hearing, Protesters can't gather in those restricted zones. But that's not the final judgment. On November 5th, when the court resumes, the respondents, Sowore and others, will have the opportunity to present their arguments and ask that the order be vacated. This is where things might get dramatic. Because Sowore is not known to back down easily, he's likely going to appear in court, defend his stance, and speak strongly about constitutional rights. And from experience, such hearings often draw large media attention, human rights groups, and sometimes even international observers. Now, let's also talk about the wider meaning of this. In a democracy, there will always be tension between the state and activists. It's almost like a balancing act. The state wants peace and order. The activists want voice and visibility. The truth is, both are important. But when one side begins to dominate or silence the other, democracy starts to shrink. And that's why this court case is important. It's not just about Sowore or Nnamdi Kanu. It's about whether Nigeria will continue to allow peaceful protests or whether the space for public expression will keep narrowing. Many Nigerians are watching this closely because it's not only activists who protest. Everyday citizens do too, whether it's about fuel price hikes, minimum wage, or insecurity. So how the courts decide in this matter could shape how future protests are treated. Now, let's touch a bit on the Free Nnamdi Kanu Now side of the story. This movement is rooted in the long-running IPOB case and Kanu's detention since he was brought back to Nigeria in 2021. Despite several court rulings ordering his release, the federal government has refused to free him, citing pending appeals and national security concerns. That's why activists, including Sowore, feel it's time to speak up again peacefully. But the police, as expected, argue that such protests could inflame ethnic tensions or cause unrest, especially around government buildings. So when you hear people online or on the street arguing about this case, it's not just about whether a protest is right or wrong, it's about trust. Nigerians are asking, can the police and government truly handle protests without clamping down unfairly? Now, here's what to watch out for next. Will the court sit on November 5th and actually hear the matter fully this time? Will Sowore show up personally? And what will he say? How will the police defend their position legally beyond just saying security concerns? Because, for a court to uphold that kind of restriction, the police must prove that the threat is real, not just speculative. And while we wait for that hearing, you can expect more online debates, more public reactions, and maybe even statements from human rights lawyers and political observers. Before I wrap up this part, let's not forget that what's happening to Sowore today could happen to any citizen tomorrow, especially in a democracy where people are passionate about national issues. It's always about balance, and it's up to the courts to draw that line fairly. If you're still with me in this gist, you deserve a thumbs up. So please, click the like button, subscribe, and share this video with someone who loves staying updated about Nigerian news and politics.